been very good about keeping to time so far, apart from Mr. Naylor, who went a minute over. But what we thought we would do, as we have about half a day in hand, is we will sit at 10 o'clock tomorrow, but that is with a view to finishing at lunchtime. So we'll still have the same amount of time for everybody's submissions as is currently scheduled, but and that gives us an extra 30-minute margin just in case there's bits and pieces to tie up. Yes.
My Lord, I'm sure everyone's grateful for that indication. My Lord, this is my Lords, my Lady, this is the Why Not Bar Guild. And in this case, I'm here with Miss Sushma Ananda. And the respondent is represented by Mr. Richard Chapman, AC, and Mr. David Hoffman. My Lord, I was going to raise the issue of timing with you at the outset. The two cases of Why Not Bar and Kaizen go together because there are common points in relation to medical officer of health. And they were allocated in the timetable a total allocation of 3 hours and 20 minutes. So essentially about 1.5 to 1 hour 40 minutes for each case, which was substantially less than any of the other cases. Lord, all I was going to ask is, could we expect your indulgence if we slightly go over our time estimates for our allotted time? We won't finish this afternoon in any event, because the time allotted to us, as I say, is 3 hours 20 minutes. But if we could possibly, and if necessary, have some of the time tomorrow morning from 10 o'clock, because I think the timetable allows for a wrap-up session of 55 minutes at the end of the hearing.
Well, if necessary, yes, but within the constraints of what I just said. But we have now heard quite a lot of submissions on causation, and I think we are only really interested in hearing new submissions, not old submissions repeated in different words.
Yeah, certainly take that on board, my Lord. I've got 3 topics to cover, and Mr. Howie will be addressing the same point. It's the question of the medical officer of health of the public authority.
Yes.
We've got a causation argument in Why Not Bar. I will have to spend about 5 minutes on that, on causation, because the wording is different. And we have got a knowledge point in Why Not Bar as well, again, which will be self-contained.
Yes, well, we do. I mean, we do want to hear the points arising out of different wordings, obviously, because they may conceivably make a difference.
But in the the Why Not Bar case, can I ask you to start by taking up the policy schedule? It's at 47, CB 47 1177. And you will see that at 105, the policy period is 2nd of November 2019 to the 1st of November 2020. You'll then see over the page at 1007, there are various sections of the policy, which is as either to buy a second section of cover. So I just wanted to draw attention to very quickly. For instance, legal expenses is not included. Now, the reason I raise this particular section must have the same meaning, regardless of whether the person has bought the other subsections of the policy. It's got to be, so you can't say it's got a different. Somebody who hasn't bought subsection 10 here cannot be expected to read the wording of subsection 10 and take into account the wording in the judge in his analysis. Public authority wording come from subsection 10 of the policy, where the words government or local. That's just a word of caution in relation to that. And the other point, my Lord, if I can just show you that in the Brian Layton case. is at 34 of the authorities. At page 1089. At paragraph 72. That was a case where you were being asked to construe exclusion 9 of section 1 of the policy, and reference had been made to the use of the words directly or indirectly in other sections of the policy which had not been taken up by the policyholder. And you will see there the way in which you address that point, my lord, at paragraph 72. My lord, can I just ask you to keep the authority open? Sorry, Lord Justice Popplewell, can you keep that authority open? I just wanted to take you 2 more points in that. It's 34.
This is the policy.
I see, sir.
I've got the authority open.
Ah, in 34. So the other point, we're on, it's just a very short point. In paragraph 71, in the judgment of Lord Justice Males, halfway down, he discusses the wording and says, the principle that where parties use the same language within the same clause, it is presumed that they mean the same thing in each case, would suggest that the same applies to the use of the words caused by in the open exclusionary wording. And the same, my lord, appears in the judgment of Lord Justice Popplewell at paragraph 42. Halfway down, again, the natural presumption is that words, where words, the same words appear, they connote proximate cause for the reasons already given, and for internal consistency within the clause, where parties use the same language within the same clause. The presumption is that they mean the same in each case. And my lords, my lady, that's a point which will just crop up in due course, as you may well have picked up already. He appreciates that it is a presumption, but it is a presumption which is well founded. Can I go to the wording then? This is at Core Bundle 46, 951. And it is obviously extension.
I can't remember enough about the case, but it looks to me as if Lord Justice Popplewell and I might have been making opposite points rather than the same points. And if so, his is the majority judgment.
Well, do you mean in relation to the presumption?
Certainly both making the point that the meaning of the clause must be the same.
Yes.
But it looks as if he was more prepared to look at other sections of the policy
my lord,
to cast light on the meaning of the clause which had to be construed than I was.
I accept that, my lord, if you track back to what Lord Justice Popplewell did say, but I think he just he said caution must be exercised in going too far. And I think you, my lord, with all due respect, and you have a much more intimate knowledge of what you meant than I, were prepared to make a more broad-ranging assertion in relation to that. But the point is there in any event.
Okay.
Yes. Yeah. So on the policy wording, then, we're at page 951 of the extension. It's extension 6. And this is 6A, which we're concerned with primarily, but obviously we're concerned with the whole of extension 6. And 6A, well, you've got the wording there for yourselves. And apart from a similar clause in the Kaizen case, this is different from any of the wordings considered in the FCA test case. So no one has had to consider the issue before of what is the meaning of the medical officer of health of the public authority. There are some additional aspects aspects of this clause which point to it being carefully circumscribed cover. It doesn't simply cover any and all closures or restrictions placed on the premises by any authority. It has a number of tightly drawn requirements. That is to say, the closure or restrictions placed on the premises have to be on the advice or with the approval. That's the first point, which I don't think has cropped up before. Secondly, of a particular officer of a particular authority, namely the medical officer of health, the public authority. And I note the definite article before both of those words and the capitalization of the terms. That's obviously not determinative, but it's relevant. And doesn't say a public authority. And the additional point is that the closures or restrictions have to be the result of notifiable disease, not just occurring anywhere within a radius, but manifesting at the premises. And as to the meaning of the word manifesting, see the Supreme Court Declarations, paragraph 7, at Authorities Bundle 3224. You needn't go there. It requires diagnosis or the displaying of symptoms. Now, the other subclauses of Extension 6 also provide important context when construing the extension. And, my lords, in prior cases, consideration has been given to the nature of the other extension, the other subclauses in the context of causation. We are not dealing with the causation issue here. We're dealing solely with the interpretation of Extension 6. And we say these, on any view, must be relevant and important as part of the context in which 6A falls to be understood. First point to note is that the phrase the public authority appears not just in 6A, but also in 6C, concerned with defects in the drains and sanitary arrangements. And these are exclusively local premises-specific matters. And importantly, in Extension 6C, the public authority is followed by the words for the area in which the premises are situate. Now, we say that's an important part of the context provided by Extension 6, namely that the same phrase with identical capitalization and use of the definite article appears in Extension 6C and not just A, which is the subject of the claim.
But without the qualification of for the area in which the premises are situated.
Absolutely correct, my lady. But it doesn't, we can't speculate as to why those words were not used in 6A.
Well,
but
draftsmen normally, if they intend to use the same phrase, will use it in both places. If they don't, the presumption is that they've omitted it for a reason.
Well, my lady, that is one way of looking at it. We say the presumption which is to be applied, it's the use of the term the public authority, which is the relevant point. And in 6C, it is obviously used. In 6A, can't speculate on the drafter's intentions. But what may have happened here is that the drafter uses the word medical officer of health of the public authority. Now, we say both of those expressions, medical officer of health and public authority, point to the local authority, the relevant local authority for the area where the premises were situated. So in 6A, it wasn't necessary for the draftsman to go as far as he or she had gone in 6C, because the point was already made in relation to the public authority by reference to the medical officer of health, which is a local authority appointment, and I'll come on to that. But the perils in Extension 6 share a common characteristic of being localized perils. I needn't read those out. You'll see A to D are all concerned with matters happening only at the premises and nowhere else. And the issue, therefore, is what is the meaning of the phrase medical officer of health of the public authority in Extension 6A? And specifically, what officer and what authority was intended to be identified by that wording? And at a more granular level, the question is, does the phrase encompass medical officers advising national governments, whether that be the devolved governments in Wales or elsewhere, or the UK government, or is it instead properly construed, referring only, as we say, to authorised officers of the local authorities concerned with local questions of public health, including disease in the local area, where their functions corresponded with those formerly exercised by the medical officer of health. So the phrase is referring to the modern day equivalent of the medical officer of health. As you know, Mr. Justice Jacobs held that the phrase does encompass the chief medical officers or other officers of the four nations of the UK advising national government. And the declaration made by him is to that effect at Core Bundle 27371. You'll see, just to be clear what he did say, it's at 371. The medical officer of health can include a relevant medical officer at the Welsh Government and the UK Government and is not restricted to a local authority. I needn't read the rest. My lord, my lady...
So I mean, in a nutshell then, nobody is suggesting that because there is no longer such a thing as the medical officer of health of the public authority, the cover is illusory and the search is for the appropriate modern equivalent.
Correct. Correct. We say the judge's conclusion was wrong. Before I go any further, can I make just these introductory points? There is no dispute in this case that the medical officer of health was a role that formerly existed. Secondly, that role was abolished in the 1970s as part of the reorganisation of the NHS. Thirdly, when it did exist, it was a local role concerned with local issues of public health, including infectious disease. Fourthly, when abolished, the powers of medical officers of health under a range of statutes were transferred to local authorities. And that's all in the agreed facts for Why Not Bar, paragraphs 18 to 28.
And only to local authorities. There were no functions formerly exercised by medical officers of health that became exercised by national bodies. Is that what you're saying?
Yes, they were transferred to local authorities, yes. It's also common ground, that the term medical officer of health is deployed in modern legislation. And important, and we say crucial to this case, and we say it's an area, it's a point which the judge overlooked. Crucial to this case is the statutory context provided by the principal pieces of legislation which are of direct relevance to the subject matter of Extension 6A. That is to say, the authority responds to notifiable disease risks, and those pieces of legislation are the Public Health Control of Disease Act 1984 and the Health Protection Notification Regulations 2010 and its Welsh equivalent. Can I just introduce you? I'll come back to Section 74 of the Public Health Act. It's at Authorities 50, 1340. And you'll see this is Section 74. This is the definition section, the interpretation section of that statute.
I'm so sorry.
1340. I may have.
No, I'm sure it's my fault. there now, thank you.
Oh, tab 50. I'm so sorry. It's tab 51. That's why my authorities bundle was compiled in paper form before something extra was added, so I'm one behind, as usual. 51. It's 51. So there, in this Act, unless the context otherwise requires, authorised officer in relation to a local authority means A, an officer of the authority authorised by them in writing either generally or specially to act in matters of a specified kind or in a specified matter, or by virtue of his appointment and for the purpose of matters within his province, a proper officer, note the word proper officer, of the authority appointed for purposes corresponding to any of those of the former medical officers of health, surveyors and sanitary inspectors. And then if you go in over the page to 1341, proper officer means in relation to a purpose and to an authority, an officer appointed for that purposes by that authority. And then if you go on to the notification regulations, which are in tab 58, tab 58, page 1434, sorry, tab 59, page 1434, and these are the regulations which require notification of notifiable diseases. And you will see at page 1435, regulation 2 says a registered medical practitioner must notify the proper officer of the relevant local authority where R has reasonable grounds for suspecting that a patient P whom R is attending has a notifiable disease. And then on the notes in page 1436, you'll see these are the notes to the Westlaw version of the statute. It says see subsection 74 of the Public Health Control of Disease Act, which for the definition of a proper officer, which we just looked at. But that note is entirely correct because under section 11 of the Interpretation Act, where an enabling act uses expressions, they are to have the same meaning in the subordinate legislation, so that the note is accurate. So there's proper officer used in the notification regulations. Now, these the notification regulations and the Public Health Act 1984 were extensively referred to both in the Divisional Court and in the Supreme Court judgments in the test case and other relevant COVID-BI cases such as Lord Manser's award. And we say that they form part of the relevant statutory background against which the contractual provisions in our case are to be construed. And the third point, the last point I wanted to mention in these introductory points is that by the end of our case and Kaizen, it was also common ground that the role of the medical officer of health included local authority officials who were not medically qualified persons. In other words, it could include environmental officers. Now, those matters should not be controversial, and I'll return to the statutes just in a little more detail if I have time later. But it's very important to note, however, that however interesting the historical role of the medical officer of health might be, it is no part of our case that any reasonable policyholder could be expected to have been familiar with that historical background. They might have been, but it obviously could not be assumed. That's the historical background. Therefore, this case is not about delving back into Victorian statutes to find out the history of the position of the medical officer of health. It's not a case about legal history or medico-legal archaeology. To the extent that any statutory background is relevant, it is to be found in the current statutes which govern public health and which have formed the bedrock for much of the reasoning in the cases so far. Reliance upon relevant statutory background is obviously permissible in this context, and we say required. The case of Dolman against Shaw is a striking example. It's referred to in Mr. Howie's skeleton, but can I take you to that briefly? It's authorities bundle, I've got 20, but it's 18, 21.
So does it follow that it wouldn't be part of the factual matrix known to a policyholder that the functions formerly exercised by a medical medical officer of health would now only be exercised by a local authority?
Well, it would be part of the, because the medical officer of health.
You told me that is in fact the case as a result of the reorganisation in the 1970s.
It's a local authority.
Unless the policyholder knew about the historical functions and the new functions and the reorganisation, they couldn't tell, could they, just from the regulations and Section 74 of the 1984 Act, that there were no former functions exercised by national authorities?
No, but what they could know from the 1984 Act is that what was being referred to was the functions which were specifically exercised by that medical officer of health in his local role. And that's what they're to be taken, we say, as understanding. So that when the policy extension is referring to the medical officer of health, it's referring to the modern day equivalent. The people who in these days carry out those local functions which were hitherto performed by the medical officer of health.
I understand you say that, but I'm not sure why you say Section 74 of the 1984 Act would tell someone that those functions can only be performed now by a local authority.
My Lord, sorry, let me just pull up the Act again. It's at tab 51, sorry. Well, what it is saying, well, a proper officer, for instance, my Lord, the one to whom notification has to be given under the notification regulations, which we've just looked at under section regulation 2, a proper officer of the authority, that is an authorised officer of the local authority.
I understand that point. That wasn't the point I put to you. But the point I put to you was whether a policyholder, if he isn't to know what all the functions previously exercised were by a medical officer of health, could reasonably be expected to know that all those had devolved to local authority officers and none of them had devolved to national authorities.
Well,
does one get that out of Section 74?
Well, one gets that, my Lord, out of the common ground which was agreed between the parties in the agreed facts. I summarised it to you, which was.
But with respect, that's not the right question. It may be common ground that is the position, but we're looking at what is legitimate factual matrix in conventional sense, or what it would be reasonable to expect the policyholder to know for the purposes of construing this section. And they're not the same thing.
Yes, the section 74 is a reference to the MOH being a local officer, and there's no reference to the MOH being anything other than a local officer in any other legislation.
Well, what it provides is that the local authority may, or let's say shall, appoint someone who will be authorised to carry out any of the purposes which correspond to those of former medical officers of health.
Yes.
Doesn't follow that no one else will.
Well, but it does mean that the local it means that the local authority can do that, though.
Yes.
That will appoint people to carry out the functions.
Yes, not doesn't say all the functions.
It doesn't say.
It doesn't say must appoint someone to carry out all the functions.
Well, I accept it doesn't say only there, but we say the implication of that is it's a local authority appointment, and it's the local authority appointing someone to do the equivalent of those.
Well, I understand that, and I mean the reason I asked you when you were introducing what was common ground, whether there were no functions that were transferred to national bodies,
Yes.
is that certainly wouldn't be apparent to me without knowing A, what all the functions were that were previously exercised, and B, how the reorganisation has worked, and what former functions are now exercised. I'm not for a moment challenging that what you tell me is right.
Yes.
I'm just saying it wouldn't have been obvious to me without knowing what all those former functions were, and therefore perhaps not obvious to the policyholder.
My lord, what we say is a reasonable reader wouldn't need to know about all the functions of all the functions of medical officer of health, which that officer formerly held. What that reasonable reader reading section 74 would know was that the reference to the role of the medical officer of health indicated it was a local authority position. It's equivalent. So that it's the modern day equivalent of the person who was appointed by the local authority to do certain things.
But it is, I think, quite important to your submission that all the functions have been transferred to the local authority. Because if some had been transferred to a local authority and others had been transferred to a national authority, then simply defining this by reference to someone who exercises the previous functions of a medical officer of health wouldn't tell you whether that was local authority or national authority. And that's why I'm just pressing you on the extent to which a policyholder would know that they had all been devolved to a local authority.
Or to put matters perhaps slightly differently, but I think it's the same point, suppose that the former medical officers of health had both national and local functions, this section would still make perfect sense.
Yes, but it would be, this is talking about an authorised officer of the local authority. So it would still bring to the attention of the reader that when you are referring to the functions of the medical officer of health, you are referring to a local role. I was going to start actually by taking you quite quickly, I hope, through the judgment, just to see the way in which the judge analysed these issues. And if I can do it as quickly as possible, if we start at 315, it's page 449 of tab 28. And the judge, this is the discussion, starts off, and he says, I consider applying relevant principles of construction, etc. Policyholders would understand the words public authority to a broad meaning which includes national governments. And then he goes on to find support for that in Declaration 9 in the Supreme Court declarations. We say that's irrelevant because the Supreme Court was not considering this policy, and no assistance should be gained from that at all. Then he says, I accept, of course, that words used in a contract may take their meaning from the context, but I see no reason to give a restrictive interpretation to the broad expression public authority by reason only of the matters relied upon by insurers. Then he discusses at 317 through to 324, various other places in the policy where the words public authority are used, sometimes in connection with public or local authority, sometimes public authority, local authority or public authority or government. But at 320, he says, I do not attach significance to the fact that sometimes words are capitalised and sometimes they are not, so he's rejecting that point. This is indicative of a policy which in this respect has been drafted unevenly with insufficient care or thoroughness. It's also apparent from other matters the absence of a definition of public authority, even though it's been capitalised, and Mr. Highe's acceptance it's not possible to identify a consistent meaning to that expression throughout the policy. All of these matters, to my mind, serve to reinforce the conclusion that public authority, he doesn't use the definite article, should simply be given its ordinary broad meaning. It says, why not bar is scarcely any better, and it's not possible to discern from other clauses any intention that the broad term public authority should be read as limited to local authorities. He says there's no definition of public authority in 6A and 6C. That is correct as it stands, but of course our case is that the words of the area where the insured premises are situated does provide the meaning of public authority, certainly in 6C, and it should be read in the same way in 6A. Then if we come down to 323, the last three lines, he says, in the light of both these clauses, it can fairly be said that if the draftsperson had wanted to confine public authority in 6A and 6C, it could have said so. He goes on to accept that's not necessarily a good argument in terms of the normal rules of construction. But he then adds at the end the use of the expression elsewhere in the policy, the fact that the simple expression local authority is not used at all lead to the conclusion public authority should be given its broad, ordinary meaning, whatever that is. Then he goes on in 325 to consider the overlap of powers between local and national government, including in relation to disease. And over the page at 326, he refers to Lord Mance in Taiping, because he's talking about the overlap between local and national government. But he doesn't actually complete the reference to Lord Mance in Taiping, where Lord Mance goes on to say, and you've looked at this before, it all depends on the context, and you cannot assume that any clause was designed to include all types or levels of intervention. It depends what the wording of the particular contract says. Then at 327 to 329, line 5, he gives his view on public authority. The last line of 327, he says there's, in my view, every reason to give public authority the broad meaning which it would ordinarily have. Then 328 is important, because he says all these considerations lead to the conclusion, without, in my view, the need to consider in detail the expression MOH, without looking at that any reasonable reader of the policyholder, and in particular reasonable SME, would conclude that public authority must include national government. And then 329, the obvious conclusion that the reasonable reader would then draw is that the expression medical officer of health in the context of provisions which refer to advice or approval would without doubt include the senior national government medical advisors on health matters. The well-informed reasonable reader, at least in England, would know that the most senior officer has the title Chief CMO. So then he comes on, in paragraph 30, he says, 330, I don't accept that any reasonable reader of the policy would go through the sort of analysis posited by the insurer's submissions based on the history of the position of the MOH, which by the time these policies were written had not existed for nearly 50 years, and then reach the conclusion that the expression public authority should be read down to mean local authorities only on the basis that the long-defunct position is a local position and that the functions formerly exercised by that officer had been transferred to other local officials. And my lords, my lady, that was no part of our case at all, the history of the role of the history of the position of the MOH. And at no stage did we suggest that the words public authority should be read down to accommodate medical officer of health. What we argued was that it was a composite phrase and they had to be construed together. But having made that point in 330, the judge then goes on in 331, and he attributes that argument to us, and he dismisses it as being an argument which would be relied upon by a pedantic lawyer. And then he says, the argument produces the strange result that the obvious person who, giving public authority its ordinary broad meaning, comes within the expression medical officer for health of or for the public authority, namely the CMO, is outside the expression, while at the same time less obvious people operating at a local level who have no qualifications come within it. And what the judge has done here, having decided that public authority includes national government, he's got it in his head that that is capable then of including the CMO, and he's also got the word medical in his head, and he's saying it's strange if the CMO isn't included in that. But that's only because the judge has built those assumptions into his head when he came to this point. Now then we go on in paragraph 332, and he refers then to the 1984 Act and the authorised officer, and refers to Mr. Howie's excellent submissions on the point. And he says, 4 lines up from the bottom of that, these include, or at least may include, officials who have no medical qualifications, such as environmental health officers, and other people who may have no medical qualification. And then again, he says it would be a strange conclusion that all of these officials were to be regarded as medical officer of health, but Professor Chris Whitty was not. Well, my lady and my lords, it's the same point here. It's only strange because the judge has got this preconception, we say, that the MOH can include reference to someone in national government with medical qualifications. That's where he's gone wrong. Now, when then we come on to the paragraph 333, it's almost as though the judge realizes he's gone too far and he has to row back, because he says, that said, I accept that a reasonable reader would conclude that given the width of the expression public authority, it included local authorities, and therefore those who at a local level occupied positions which were similar or equivalent to the Chief Medical Officer of National Health, who had a similar advisory role. I do not need to decide whether or not that would extend to every local official, whether qualified or not, who has a function corresponding to the former medical officers of health. And then he records the agreement between the parties that the role of the MOH wasn't limited to medical officers. Sorry, no, I've missed out in 333. I've gone to, then in 333, it's in the second sentence, first sentence, sorry, I missed this out. A reasonable reader would conclude, given the width of the expression, public authority, it included local authorities, and therefore those, sorry, I did read this, at a local level occupied positions which were similar or equivalent to the Chief Medical Officer of the national government or who had a civil advisory role. Now, no such equivalent position has been identified by anyone. It was not anyone's case in relation to this case. But so what has happened here is the judge has ended up with the conclusion that the person being referred to is someone who's equivalent to the Chief Medical Officer of the national government or who had a similar advisory role, but who didn't need to have medical qualifications. And so what we say, what he has done here, is failed actually to identify properly who the medical officer of health actually is. It must, he's accepted, if the clause is to work in a pragmatic way, it must respond to intervention by non-medically qualified. The word medical is wrong. And that which the judge dismissed as being strange is anything but strange. So that's what the judge's reasoning has taken him. It's taken him to the basis public authority, very broadly defined, very includes central government. Therefore, I take that into account when I'm construing medical officer of health, and I take into account the fact it uses the word medical, and I find myself driven down this route. But then he has to confront the reality, which is intrinsic to this clause, that the person exercising most of the functions contemplated in Extension 6 will be local officers of health, because they're all parochial matters.
Well, it's 6A that we have to focus on, isn't it? We don't get medical officer of health in any of B, C, D or E, do we? So we're not concerned with vermin or drains or whatever.
Yeah, no,
We're looking at functions in relation
Yes.
to notifiable.
Yeah. So
Diseases.
that's what he rose back from, and so what he's left with is it's an officer who has functions which can be environmental. But
what sort of non-medically qualified local authority personnel would be involved in relation to notifiable diseases?
well,
Closures as a result of notifiable diseases.
well, local authority officials, my lord. We're talking about this as well. Environmental officers who close. I'll give you an example, and it's Mr. Howie's researchers which have brought this up, and he'll take you to it in more detail. But he's got an example of an environmental officer of East Staffordshire Local Health Authority closing down premises because of the existence of the Legionella bacteria. So there's an example, my lord.
And having no medical qualifications.
He's an environmental officer. I mean, we don't know, but I mean, that's the position. My lord,
That's rather important, isn't it?
Well,
and I quite understand that there will certainly be environmental health officers who may close down premises for all sorts of health and safety reasons who are not medically qualified. But that's not quite what we're on, because we've only got this for notifiable diseases in 6A. And you may well be right that there will be non-medically qualified local authority officers who are the people who either close down or on whose advice you close down for notifiable human diseases. But that's just not self-evident to me in the way it is self-evident in relation to other aspects of environmental health and safety.
my lord, yes, but we in this context we say that Extension 6A has to be read in the context of the extension as a whole. And you do get, in the context, in construing 6A, it's perfectly legitimate, we say necessary, to have regard to the companions, the SOCI, in the rest.
None of which require a medical officer of health to be involved at all.
No, but they do envisage intervention at this narrow parochial level. I've just been past CB 28. Oh, in the judgment the judgment paragraph. Is that paragraph 452? Page 452. Which page? Oh yes, sorry. Yes, yes. Sorry. Yes, I did the parenthesis, my lord, at paragraph 333 of the judgment. So the local medical officer of health would include, and if you tie that back to the last 5 lines of paragraph 332. He's accepting they may include environmental health officers.
The closure has to be on the advice or with the approval of this elusive person that we're talking about. Does that not suggest that it's got to be somebody who is in a position to give advice about the effects of notifiable diseases and therefore, in all probability, to have some medical qualification?
Well, it doesn't mandate it, my lord. It could be. Medically qualified people aren't excluded from the functions previously carried out by the medical officer of health. But it can go further, and it can include non-medically qualified people.
I would expect it to be somebody who has enough medical knowledge, whatever his or her formal qualifications, to be able to judge whether the notifiable disease is such as to require, by reasons of public health, closure of the premises.
Well, my lord, as I say, that we've certainly got the known example of an environmental health officer ordering the closure of premises for Legionella bacteria. Now, I know we don't do it,
One
but
would expect such a person to have a qualification, not in the formal sense, but the qualification of knowledge about the public health consequences of Legionella. That may be all that medical needs.
my lord, I don't dissent from that proposition, that you would have to have that sort of awareness about the public health implications. Yes, absolutely. But it doesn't, I don't accept you would have to be a medically qualified person.
No.
You could have awareness of the public health implications of the spread of the legionellosis bacteria, whatever. Yes.
If one's not using medical in a defined sense,
No.
then
Yes.
that might be what medical means.
Yeah. So that is in relation to the judgment. And can I just briefly tell you, I mean, we've got 4 criticisms of the judgment, and then I'll come and tell you what our construction is of the relevant clauses. First, very quickly, is judge adopted an overly literalistic construction of the kind deprecated in Wood and Capita, focusing on the literal meaning of medical and an acontextual meaning of public authority. Secondly, he ignored, or at least gave inadequate attention to, multiple points of statutory and contractual context. You've got the references already. Thirdly, he decided that the CMO would be encompassed within the phrase MOH of the public authority without identifying a clear meaning to be given to that phrase. And effectively, he ended up construing the phrase as capable of referring to any officer of any authority. Which is plainly not what the clause says. Fourthly, he failed to construe the phrase medical officer of health of the public authority as a composite whole and to give equal weight to all of its constituent parts. So with that, can I just look at the word public authority, which you have in the clause before you. As I say, we are not relying upon the meaning of the medical officer of health to read down the meaning of public authority, to restrict it in any way. Instead, our case is that both parts of the composite phrase are consistent and they uniformly point to the local authority and the officer being an authorised officer of that local authority. And this is, I've covered the point, sorry about Declaration 6, I can go on to that. So the starting point, the phrase is not public authority, small p, small a. It is the, capital P, capital A, authority, with capitalisation and the definite article. And the judge, we say, misunderstood the significance of this point. 320 of the judgment I've shown you already. It wasn't any part of our case that the use of the definite article and capitalisation was sufficient in itself to point to the public authority being a local authority. Instead, the significance is threefold. First, it suggests that what's being referred to is a particular type of public authority. Secondly, because the very phrase with its identical use of capitals appears a few lines later in extension 6C, the clear implication is that the same particular authority is being referred to in both extensions. Consistency of language. Thirdly, it draws a point of distinction to other uses of public authority in the policy. The phrase the public authority only appears in extension 6 and nowhere else. Fourthly, it underlines the limited relevance of other usage of public authority or public authorities elsewhere in the policy.
So it underlines
Under
limited usage
exactly.
of public
Other
authority or
usages of, yes.
Sorry. The limited usage of public authority
or public authorities in the policy, other than to emphasise that the usage in extension 6 is unique.
Can I just explore for a moment the extent to which those are independent points? I entirely understand your point by reference to 6C. The public authority should have the same meaning in A as it's given in C.
Yeah.
But the point against you on that is, well, you don't get the qualification for the area in which the premises are situate, and then you move to medical officer of health. But leave aside for the moment what you can derive from the use of medical officer of health. If one were just looking at A, one might think that the public authority was referring to the body that imposes the closure or restrictions. One would expect the definite article, rather than the indefinite article, closure or restrictions placed on the premises, brackets, on the advice or with the approval of the medical officer of health, of the public authority that's closing or restricting.
Yes, but that is true. But that and if it weren't the accompaniment of the words medical officer of health, that's why it's vital to look at this phrase as a composite whole.
Well, I understand that, and one can come at this from various directions. There's various moving parts, but I'm just wondering whether the focus that you're on at the moment, which is the definite article and
yes.
capital P, capital A, public authority, has really rests on your 6C point, or whether it's got some independent life.
It does,
trying to explore.
It does have some independent significance because elsewhere in the policy, even outside those section 10 points, which I showed you about uninsured sections and so on, there's the use of words public or local or governmental authority or whatever. And so elsewhere, nowhere else in the policy has the draftsman chosen to say the capital P, capital A public authority. That's the point. It's a unique usage in the policy. There's obviously been a deliberate decision taken in this the context of this extension to refer to it in that way.
But capitalised P and A, you say, is a definition intended specifically to mean a local authority, do you? I mean, that's why you say that's why it's been capitalised as a
yes,
define. In effect to define term,
it's effectively
which it wouldn't have if it was small p, small a.
It's effectively a definition, and although it doesn't appear in the definition section, we do rely upon. So I've taken board the observations of Lady Justice Andrews, but we do rely upon 6C, and we say it's a clear indication.
Yeah. Thank you.
And the public authority point, my lord, in addition to 6C, just to repeat the point, is extension 6 generally is talking about local perils. So, in relation to that, I think I have got through most of the material on public authority. Yes, additionally, the definition of the public authority as a local authority actually makes perfect sense in the context of Extension 6, perils contained therein. And that's a point obviously made by Lord Manson, the China Taiping arbitration, and paragraph 88. I can invite you to read that again, because as I say, Extension 6 is dealing overall with these highly localized parochial matters, in respect of which local authorities, local police have the power to act. And these are not matters which are likely to attract national authority response. They look, things like food poisoning, defects in drains. We are in the context in Extension 6 overall of localized action.
Sorry to keep interrupting you, but I could just ask something whilst I think of it. I'm just wondering what the words "with the approval of the medical officer of health," or on the advice or with the approval of the medical officer of health, are intended to add. If it simply said closure or restrictions placed on the premises by the public authority as a result of notifiable human disease, assuming, as you say, that means the local authority, well, then it would cover cases where the local authority closes it down due to, as a causative link, notifiable human disease, which begs the question, well, why is there an additional requirement that the closure has to be on the advice or with the approval of this person, which might seem to suggest that all that is intended to be achieved by that is that it shouldn't be a local authority decision taken without reference to some medical criteria in public health terms. And that's the medical aspect of what's being added by medical officer of health of the public authority.
Well, my lord, it could be, but it is not exclusively that. And it could be, as I say, it could be an environmental officer taking the decision. And that, as I say, was accepted that proposition, that it could be non-medically qualified persons. Your Lordship's question, though, opens up another very important point, though, about it's an issue which I have to come on to in relation to knowledge. And this wording, and I've addressed your knowledge in relation to Hair Lab before, and the point has come up, but in the context of this policy, this wording, those words "on the advice or with the approval of the medical officer of health" strongly point, in keeping with other parts of the clause to which I'll come in due course, strongly point to the fact that this extension is contemplating closures or restrictions taken on the advice of the medical officer of health, who therefore has knowledge, informed knowledge of what is happening, informed knowledge of the notifiable human disease manifesting itself at the premises. Now that's a separate part, but it's an important part.
Well, we go back to our measles example. I'm not sure that the fact you have a medical officer of health means that the person who's taking the decision, if they are the medical officer of health, has to know of the existence of the disease at the premises. But that takes us back to the debate we had.
Yes.
In relation to measles and nurseries and so on.
I won't.
And I'm not inviting you to read it.
No, of course. But the words "on the advice for approval" we say are important because they bring in an additional element into this clause which is absent. I don't think they appear in any other clauses you have seen. And we say that it's implicit in those words that if someone's going to give advice or approval, they can only give advice or approval if they've been informed about the facts.
Yes, but what facts?
well,
There we are.
can I move on to the medical officer of health? I think actually in relation to this, again, this is a definite article with capitalised medical and capitalised health. It is a specific officer. It's not just any old officer. The draftsman had in mind a specific position, a type of authority, official, or officer, and that's what we are concerned with here. It's not, I mean, it could have said the chief medical officer, but the draftsman obviously chose not to do so. Sorry, just see, I've been through the statutory context, but what we say generally in relation to medical officer of health, in fact, the conclusion reached by the judge that it could include people who are not medically qualified is right. It shows that the literal meaning of medical officer of health cannot be the right one. And so you therefore have to explore what is being intended by medical officer of health. And that's when you go into the statutory context, my lords and my lady, and I've taken you through that, and I'm not going to return to it, not least because I've already exceeded my time limit. But what we say in relation to this is that without going into ancient history or repealed statutes and consulting only current and in-force public health legislation concerned specifically with disease, the reasonable reader of the policy would conclude that a medical officer of health is a role that used to exist, former medical officers of health. The functions of that role are now performed by an officer of the local authority. That officer is a proper officer of the local authority. That's to say, an officer appointed by the local authority for a particular purpose, namely any purpose corresponding to those of the former medical officers of health. The proper officer is also an authorised officer of the local authority, and the reference to the medical officer in Health and Extension 6A is to the proper officer or authorised officer of the local authorities performing functions previously performed by the former MOH. And so that is the, we say there are 5 points which point towards the correctness of our construction. I've covered some of them already, but just to recap. First, it gives in full effect to the phrase MOH without having to give it an overly literal interpretation that focuses on medical. Secondly, it derives support from the current principal statute, as you've seen. Thirdly, it would be illogical and irrational if reasonable policyholders were not imbued with knowledge as to the meaning of medical officers of health derived from those in-force statutes. Fourthly, our interpretation does not depend on trawling through legislative history. And fifthly, there is nothing of the pedantic lawyer in insurers' analysis. It doesn't involve any minute textual analysis. Instead, all that is required for the words of Extension 8 to be construed in their proper statutory context. So, my lords, my lady, that is largely what I wanted to say on MOH. Oh, I've just got a note saying break.
Yes. Well, as you said, you have exceeded the time which
Yes.
was allotted to you. What are you going to be covering now?
My lord, I will. I don't think I've got much on that. I've got a very short bit on knowledge. I've sort of picked up on some of it already, and literally about 4 or 5 minutes on causation and why not VAR.
Right.
So I imagine round about 12 minutes.
Right. Okay, that's helpful to know. We'll take 5 minutes now.
All right.
That's true.
Not really. I mean, it's, but quite honestly,
It strikes me. No, you start with the precise opposite. Start with an actual medical officer is not, there isn't what you can do. Whoever's entitled to do it, whoever fills that role, whatever is the medical.
Unless you're in an area where people know about lots of different, everyone knows there are different types of medical officers and you're picking one,
Yeah.
and it means the thing that you think that means. Yeah. If you're in a context where it's a specific thing where everyone knows the regulatory background and you're picking between different medical officers, then maybe the technical term medical officer means one, because it doesn't mean the other medical officer. But for a consumer business person,
Seems to be.
I mean, no. They haven't said, for example.
Chief is just a subcategory of medical officer.
If you're looking for
What they haven't said is whether the clause has an effect. It's OT. Right, it's a historical thing because someone that doesn't exist. So they've not said that. It's got to be made to work. So what does the person get? Nothing. If you want to update your policy to be accurate, then do it.
if you wanted to say local authority,
Change the words. It's your policy. You do change it every year.
it's not contrapropound. Don't come here rewrite the words.
Just read it every 20 years, maybe. It's
50 years.
was it 50?
Yeah. That'll take like 50 years.
Well, they just it was categorised as what in the court mind that's a physical case.
I think you were unlucky. I was sure. Oh, we made a decision.
Right? Here we go. But yeah, that's that dominant.
And what's more, his much.
I'm getting it. There's a lot of angry...
Did you beat him track?
Yeah.
There's a lot of angry syndrome things.
There was not at the end. I think the truth was, he delivered that charge. No.
You're still live, by the way.
How old are your kids?
Yes, 2 years old actually, so we're going to 17, 18.
Right,
Yes, they get over
All rise.
My lady, my lord, I just want to make two short points before moving on to knowledge and then causation even more briefly. And the first one is in relation to, well, there are 2 points arising out of some points made by Lord Justice Popplewell. This is in relation to on the approval or advice point, and whether or not that is really saying there has to be some medical contribution point. We go further than that because what the clause is saying is on the approval or advice of the medical officer of health. It has to be a specific person who's performing a specific role. So it's not just a question of someone happening to give medical advice. It's got to be through this particular identified person. And the second point
Although your case is that person is defined simply by anyone exercising a particular role.
It's an authorised officer. Yes, but it's an authorised officer of the local authority exercising the roles formerly performed by the MOH. And but also the second point, what you do see in the notification provisions, the regulations, 2010 regulations, the notification of the disease has to be to the proper officer of the local authority, which would be the equivalent of the function, I think, we say, of the medical officer of health. So I'm going to move on to the knowledge issue in Why Not Bar. And as I say, Why Not Bar, the case is different because the wording is different. We obviously, the question here, it's a standalone, it's partly parasitic upon causation, but even if we lose on causation, if we were to win on causation, then the knowledge requirement on the part of the medical officer of health would follow. But even if we lose on causation, we say there is nonetheless a requirement derived from the particular wording of extension 6 that the relevant manifestation of COVID-19 at the premises had to be known by the medical officer of health prior to that officer giving advice or approval for closure or restrictions being placed upon the premises. And so that is contemplating an identifiable officer giving advice about the occurrence of the disease at the premises. Now, we say no proper consideration was given to this argument by Mr. Justice Jacobs. He dealt with knowledge briefly at paragraph 250 of the judgment. We needn't look at it. He treated it as being parasitic on the causation issue, but then said at the end of 250, insofar as a separate point was advanced on knowledge, I reject it as being inconsistent with the Supreme Court decision and unsupported by any relevant wording in the clauses which I am considering. But the problem about saying it's inconsistent with the Supreme Court decision is that the Supreme Court did not deal with extension 6A or any similarly worded extension. And so it didn't consider the specific argument of construction that advanced in this case. And the judge didn't give any reasons to explain why the wording of extension 6A does not support a knowledge requirement. We say if he had given proper consideration to our arguments, he would have concluded that 6A contained and would have been understood by a reasonable reader to contain a requirement that the manifestation of disease at the premises be contemporaneously known by the identified officer of the identified authority prior to advising or approving the closure or restrictions. And so we point in this, in relation to this, we make the following points. The point we've already touched upon. The closure has to be on advice from the identified officer. The closure restrictions and the manifestation of disease at the premises in the second part of the extension must be considered together part of a joined up operation, joined up approach to the extension. So it's not just advice or approval, it is also manifestation. And if you look at this extension in a common sense, holistic way, we say a reasonable reader would understand that to be informed advice or approval of the medical officer of health. And the advice must be the result of a manifestation of disease. And so advice about the case of that case of disease, not advice about disease in general.
Why does it have to be advice about the manifestation of disease at the premises?
My lady, we say that is implicit because closure or restriction placed on the premises, on the advice, as a result of human disease manifesting itself at the premises.
I don't see how you even begin to get there if you lose on causation. If you're right on causation, you don't need it. If you're wrong on causation, then you can't get by the back door, you can't get by the front.
My lady, it's two separate points.
I know, but you've got to look at this, as you say, as a matter of commercial common sense and holistically.
Yes.
And if it doesn't mean one thing for one purpose, it can't mean something. It can't mean it for another purpose.
Well, the two purposes are, we say, distinct. And you get the point in the context of the causation argument. If you're looking at what is the causal requirement which is required, but if you're looking purely at the insured peril, it's what has to be satisfied in order to obtain cover, then in my submission that's a standalone issue. And what has to be satisfied is the advice, approval of advice, as a result of the manifestation of human disease at the premises. And so we say there is a requirement for knowledge at the time. It's not enough to have some retrospectively identified manifestation. It's got to be known contemporaneously and identified. And that brings me to my last topic, causation. Just got 4 points to make in this. And again, this is important. The wording of this is important in this context for 4 reasons. First, the policy covers all notifiable human disease, whether contagious or infectious or not. So extension 6A would provide valuable, meaningful cover of the very type that a restaurant, bar, nightclub, which why not bars, would want to have for site-specific notifiable diseases like Legionnaires, food poisoning, which are not contagious and which will inevitably give rise to an authority response directly at the individual premises. So,
Food poisoning notifiable.
yes. Secondly, and what is important in this clause, requires manifestation of the disease, that's to say a symptomatic diagnosed case of disease at premises. That's consistent with the authority cases acting in response to it. So it calls for a direct causal test that's consistent with the requirement of knowledge. Thirdly, I've been here already, but it requires closure restrictions on the advice or approval of the identified officer. And such advice or approval would naturally and reasonably be understood to involve some active consideration by that officer of the situation at the premises with knowledge of the disease that has manifested itself there. And that again is consistent with the causal link between the disease and the closure. And fourthly and lastly, the phrase medical officer of health of the public authority, you've heard me talking about it for too long already, but it's properly construed as referring to officers of a local authority. And again, this is indicative of a direct causal link. Local authorities are likely to be concerned with local disease at specific premises. They are far less likely to respond on a widespread aggregate basis. And those are the points which are specific to why not bar and put it in a category from other cases, apart from potential Kaizen. My lords, maybe that is my submission. Giving me more time than I originally
I am, according to the timetable, due to complete this appeal within 15 minutes. It is possible even proceeding with expedition that I may run over slightly, not least because Mr. Gruder was the other day invited to open his points on notifiability of cross appeal. And I may therefore, as it were, borrow slightly against my reply and deal with that now rather than up and down later. There are 4 issues in Kaizen. All of them by now will be familiar issues. The first is the general as to the causal requirements of an at-premises clause, in relation to which I, hope unsurprisingly, take the same position as I do alongside Mr. Keeley in X. I don't to say anything more about it. Secondly and thirdly, there are questions about whether the phrase the medical officer of health for the public authority A describes only a local authority officer and B imports a requirement as to the significance of that officer's knowledge. That is obviously common to what we have just been addressed on. I am therefore not going to repeat all of that. I do have to outline for you how those points work in the context of the Kaizen word, and I will take a little bit of time. Fourthly, liability. That is a close variant of the issue in Hair Lab, and so the general arguments are familiar that my Lord Justice Popplewell identified the other day. It is a hybrid clause, not a disease clause, and I will need to address that nuance. So with that overview, the Kaizen wording is in the core bundle, tab 42, page 856. That is a passage from a self-described small commercial SME package, which provides general purpose cover. It's a standard form policy. Free. I paid about £500. The business interruption cover starts at page 873, and as is conventional, the base cover is against business interruption arising from physical damage. The clause actually just refers to damage, but that's defined at page 840, we don't need to go there. It's physical damage. One then gets extensions to it at pages 874 and 5. The clause with which we are concerned breaks across the page, but the disease limb is on 874. That is, as you can see from the words beside little 1, a premises closure or restrictions extension, and lim A is closure or restrictions placed on the premises on the advice or with the approval of the medical officer of health for the public authority as a result of a notifiable human disease occurring at the premises. So it's obviously very familiar territory in the last hour. The reference to the public authority in the Kaizen clause works a little different, although not, as I will be submitting, materially different. The why not bar wording says public authority only twice, once in the disease limb and once in, I think it's the drains limb, but on the second occasion carries the words for the area in which the premises are situated. Kaizen wording doesn't have that phrase. What it does is it sets out the public authority in every limb of the clause. So each limb of the premises closure or restrictions extension identifies a reason for which the public authority may close your premises. And the reasons are the familiar companions. We called them the other day. Disease first, but then there is food poisoning, defects in drains, vermin, murder, or suicide. With that introduction to the word, I want to make probably only 3 points. To give broad headlines. 1, short point, commerciality. 2, the common characteristic shared by all of the limbs of the clause. And 3, the significance of the medical officer aspect. So first, commerciality. The point is simply this: it is not uncommercial or absurd or in any way odd for a clause of this type, a policy of this type, to respond only, exclusively, to local authority action. That is, as Lord Mance said in China Taiping, 104-6, an understandable aim, readily conceivable, and a pragmatic way of defining localised cover. I'm not going to go yet to Taiping, but its authorities, 64, page 1574, to give that reference. A limitation to local authority action is, in my submission, particularly understandable in a package policy designed to be sold widely and cheaply to SMEs who ordinarily would expect to encounter local authority action much more readily and much more frequently than government action, even if conceptually they couldn't. Equally, government action is capable of being greater in severity and presenting a greater accumulation of risk for the insurer, with potential implications for the price of the cover. And so there is a clear objective commercial rationale on both sides of this type of clause in this type of policy to be talking about local authority action alone. Whether or not it does is of course a matter of constraining the words. But there's nothing odd about that result if that's where we finish. That's the first point. My second point is to focus on the immediate context of the extension. Because in fact, the phrase the public authority, much like in the why not policy, is really only used in this form exclusively within this clause. There are some other clauses in the policy in which the words public authority, small p, small a, do feature.
And it's not defined as a
It's
defined
not
term.
defined, no, exactly. And I accept it before the judge, and I accept before you now, that one can't really, as it were, try to stitch together a single consistent meaning of public authority that applies in every single clause. What that means is not, with respect to what the judge recommended, which is that you give it effectively as broad as possible everywhere. What it means is that you focus on the particular context, the immediate context in which it is used. That is likely to be the most relevant reference point. And when one does focus on the immediate context of the Kaizen extension, what one sees is that all of the limbs concern perils which ordinarily, especially from the perspective of an SME, would be most likely to attract the attention and intervention exclusively of local authorities. And it's at that juncture that I do need to tilt into China Taiping, because China Taiping is a case in which that very point was made. China Taiping is authorities, tab 64. And start at page 153. That was in issue in China Taiping. We are concerned for present purposes with extension 2, which is in the bottom half of page 1532. And you see the clause that Lord Malice is there considering is a hybrid clause responding to the occurrence of the premises of murder, suicide, food or drink poisoning, disease, vermin, pests, or defective sanitation, which cause restrictions on the use of the premises or the order or advice of the competent local authority. So the policyholders can say that Taiping was a case where it was competent local authority, not the public authority, but acknowledging that to be so, the perils are otherwise materially the same as those that are contained in the Kaizen clause. It's with that in mind that we need to then turn on to another paragraph you've been shown before, but keep in mind the clause 1569, paragraph 88. And you can pick it up halfway down. The first half is the point about hindsight. I'm not going to make that plenty of time. But halfway down, the express language of extensions 1 and 2 is heavily focused on localised incidents likely to attract a response from the police or a local authority or body with local competence. And of course, as he acknowledges, there's nothing to exclude other levels of response, but the focus is on localised incidents. My lords, my lady should note that Lord Mance was not here just, or even primarily, making an observation about the words competent local authority. He was making an observation about the incidents that are the focus of the clause. Those are the incidents that are localised, and for that reason and by their nature are likely to attract a local authority response. So, my Lord, or Justice Popplewell said earlier to Mr. Christie, we're not really concerned with the upper limbs. That's not in my submission quite right, because Lord Mount is here concerned with looking at his premises closure extension as a whole, and looking at all of them, gleaning from something about the type of incident to which the form of authority referred to in every limb is responding. That's the common characteristic which then drives the construction. It obviously applies to things like vermin. You would never get national government responding to vermin or to defective trade. But certainly, in the overwhelming run of cases, you would expect the intervention in respect of disease also to be local, even if in respect of all of these things, without the benefit of hindsight, you would say national intervention is conceivable. It's not like, it's not the ordinary fact. That is part of the background that informs one's construction. The final point of background, moving on, our last point, is that of course something else you have to put in the mix is that one important characteristic of the public authority is that it engages medical officers of health. One's got to give that some significance in the construction of exercise. The judge said, 328 judgment, page 451 of the court bundle, that the reasonable reader would form a view about the meaning of the public authority without the need to consider in detail the expression medical officer of health. Well, if the reasonable reader had concluded that, or had approached it in that way, he would not have been very reasonable, because he would have read the clause backwards and stopped halfway through. The medical officer of health for the public authority is a single composite phrase, and one has to construe it as a whole, giving weight to both elements, and thus understanding that the public authority, whatever it is an authority which engages persons describable as medical officers of health, which then takes one into the statutory background and the other points that Mr. Christie has already developed. I just want to attempt a brief wrap-up of where we might have got to. And obviously we may have to come back to it in reply, but there are a few possible candidates flying around. I just want to pin them down. First, is the clause referring only to the chief medical officer? Answer, no. I think that's now common ground. It wasn't trial, or not before trial. The pleaded case was that it was either redundant or only the CMO, and nothing else. But that's dropped. Can't be only the CMO, and of course it would be bizarre if it were, given the nature and purpose and typical purchaser of this type of cover. So one's out. Two, either the CMO or the local equivalent, which I think is where the judge ends up at 333. It's not entirely clear. Now, that's not a very promising candidate, because there was and is no evidence, no agreed fact before the judge, and it isn't before you now, that there are local equivalents. So it's a construction hanging on no factual basis at all. That one. Third, it's got to include authorised officers of local authorities, because they're people who close premises based at the time. Mr. Christie mentioned the document I found. I wasn't able to get a gauge of it, but it's the first document on the first page of the supplementary bundle. We don't need to take it out. It is an example closure notice for Legionella. The closure notice is issued by an authorised officer. And what it shows is not actually anything about medical qualifications, I accept. What it shows is that authorised officers of local authorities do close premises. So you've got to, if you're being sensible, construe the clause as extending to them. Fourth point, in my submission, the clause can't only mean people with medical qualifications, because there is no evidence, no agreed fact, and I suggest no reason to suppose that those who advise the closure of premises would always, or even usually, have such qualifications. They might not, but there's no factual basis for saying that they must or normally will. So that's not really a runner either. The fifth possibility.
What do you mean by medical qualifications?
A medical degree, a license to practice medicine, something of that nature.
Training in public health matters?
Well, that's my fifth possibility, which I think is the possibility you raised in our, which is that it means medical in a slightly looser sense, not physician, but someone who knows a bit about public health. My answer to that is twofold. One, that is not in my submission, in fact, the normal use of the word medical. It wasn't the use of the word medical which I had in mind. But secondly, it's not just medical officer, it's the medical officer of health of the public authority, which is suggestive of not just anyone with training in public health, but the holder of a distinct office. So where do we end up? We end up with possibility 6, which is the construction indicated by the statutory background, with all of the reasons that Mr. Christie has. That is the construction that I recommend. I suspect I'm running short of time. Need to move to notify us. But that's the structure of the arguments as they currently seem to lie. I might just pick up one point actually before I move on. I think the point was made in the argument that you can't tell in the statute what all of the functions did. I probably ought to deal with that. Sorry. What the statute tells you in my submission is that functions of the former medical officers of health have passed to proper officers, and that they are local officers, and not only that they are the local officers who receive reports of notifiable disease, which is of course the subject matter of the law. So if it be the case that there were some other functions of medical officers of health which passed to national officers, and there's no evidence of that at all, but if that is the case, it is irrelevant because the statutory background shows the reasonable reader that the local authority officers who receive reports of notifiable disease, local authority officers, successors of the medical officers.
Is it really the case that food poisoning is a notifiable disease?
Yes,
If I go to my doctor and I say, I've had D&V, and he says, well, it's probably something you ate. He has to then notify the local authority. Well, I mean, you may be right. It just strikes me as rather surprising.
No, well, it won't take long, but it's behind tab 59, page 1448 of the authorities.
59.
Tab 59. I should say, this is the Health Protection Specification Regulations 2010.
Yeah.
I might actually just alight on 1435. Mr. Christie took you to this, but this is Regulation 2.1. A registered medical practitioner must notify the proper officer of the relevant local authority of a case of notifiable disease.
Yeah.
So that chap's the relevant successor, even if there's some successor in the Ministry of Health somewhere. This is the one we're concerned with, because he's the one who gets the report of notifiable disease. What does notifiable disease mean? Reg 2.7, page 1436, tells you it's in Schedule 1.
Yes.
Schedule 1's at 14478. 1448, about 8 entries down, food poisoning. So it is, or does it may seem? Although, of course, it's perhaps not that often. It's sold to cafes. Food poisoning is probably a characteristic notifiable disease they might expect to be told about, which is why the venture, it's covered twice. You get a notifiable disease and you get a clause that makes it explicit. Food poisoning is definitely.
Thank you.
So that's where we are on regulations. I am going to do, as I said I would do on the medical officer point, and move on from it. I'm not going to talk about knowledge. I adopt what Mr. Christie has said, and otherwise leave it on the face of my skeleton. Notifiability. It is, if I may say, quite apparent from the court's interventions towards the end of yesterday that all of you entirely understand both the policyholders' arguments about notifiability and the insurers' arguments for saying that those are wrong in the context of a disease clause. And so, unless you tell me I'm going to take all that as read, and all I'm going to address is how it works in a hybrid clause. My Lord Justice Popplewell was right yesterday to say that the question confronting us here is not one of causation, but one of construction of the peril. And Mr. Grigg was right. My Lord was also right to identify that the peril in Kaizen, because it involves a hybrid clause, presents a slightly different question with your disease, because there are two elements. A hybrid peril embraces not just the occurrence of disease, but also, if I can put it compendiously, the response to the occurrence of disease. And that, on the face of things, raises a question of whether notifiability is to be judged as at the time of the occurrence, or as at the time of the response when the peril is complete. That's just to identify the question correctly. It doesn't tell you the answer to that. Conceptually, either time could be the relevant time, which it is a matter of construction of the hybrid peril. And so one needs to go back, alas, to the policy and look at the clause. Page 874 of the bundle. Just reminding ourselves of it. One sees towards the end of the disease peril that the closure, etc., has to be as a result of a notifiable human disease occurring at the premise. That's what has to happen. Notifiable human disease is a defined term. The closure must be as a result of the occurrence at the premises of a notifiable human disease as defined. So one needs to look at the definition, which is on page 842. That's not the right route. What the definition on 842 notifiable human disease is an illness sustained by any person, caused by, we're doubling up again, but food or drink poisoning, A, and B, any human infectious or contagious disease, an outbreak of which the competent public authority has stipulated to be notified for claim. So, two things wrong, really. One, two things. First, the defined term in the Kaizen policy is referring to an actual case of illness in a person. The relevant concept is not disease in the abstract, not disease as a concept or thing. It's disease in the real world, sustained by a person. It's a case of disease. Mr. Gruder said yes. He said it in the context of the Hair Lab clause, but the Hair Lab clause is the same, so it reads across. He said, effectively, the purpose of the clause is to identify those diseases for which we can claim an indemnity. Day 2, page 132. So that I say, well, yes and no. It depends what you mean. In Kaizen, the clause does operate to identify the diseases as being those diseases which have been stipulated shall be notifiable when there is an outbreak. But the way in which it does it, as a complete definition, is by reference to the actual case of illness sustained in people from those diseases. It doesn't just say any disease on the notifiable disease list. The second element which follows from that is that it is a necessary feature of that case of disease sustained by a person that it must be a disease which the authority has stipulated, shall be notified to them. Stipulated where? One. Well, naturally, in the context of the definition, stipulated by the time of the occurrence of the case of disease in the person. The stipulation of notifiability precedes the sustaining of the illness. The illness sustained by a person is not an illness caused by a disease, not a case of notifiable human disease as defined. So in its own words, the defined term notifiable human disease really means a case of disease which is notifiable when
It means an illness sustained by any person, which is a real case, right? So somebody goes down with poisoning caused by an infectious disease which has been stipulated to be notified at any point. In other words, if it's on a reliable list by the relevant authority and somebody has it, that makes it a disease.
naturally, my lady, I suggest in the context of this wording, when one reads the whole phrase, it is just talking about an illness sustained by something stipulated as notifiable. And
Yes.
But
But it doesn't have to be stipulated as notifiable as a result of it being valid. For example, I mean, the way I read it is, it's got to be an illness sustained by any person, so somebody's actually has to have it,
Yes, yes,
right?
yes.
But it's got to have been caused by an infectious disease, which is among the diseases, let's say, that has been stipulated on the list as a notifiable disease.
Yes, and one is naturally, I accept all of that,
Yeah.
but one is naturally reading it, I suggest, in its own terms, as describing the characteristics of that disease which is sustained. It's not a link, no need to read that as ordinarily meaning something that is descriptive of the happen. Particularly when one carries it back into the clause. And in the clause, this is something that occurs at the premises. It's a form of occurrence. So, what is it that has to be occurring at the premises? Well, it's a notifiable human disease, i.e. a case of illness sustained by a person caused by a disease which is notifiable. And one naturally reads that as attaching to the time of the occurrence. I could put it another way. This is the way the judgment, 267 to 268 in its judgment, page 440. The causal chain, making up a hybrid peril, has a few different components. But that's what a hybrid peril is all about. It's A causing B causing C causing D. Is together the peril. And the peril is, 1, a case of notifiable human disease occurring at the premises, resulting in, 2, the officer advising or approving the closure of the premises, resulting in, 3, the closure being imposed, and that then interrupts the business. So the inquiry as to notifiability belongs to stage 1 of the composite peril, even if the peril is incomplete at stage 3. It doesn't matter that the peril is incomplete. Stage 3, the policyholders can say that as many times as they like, and they do, but it doesn't change the fact that notifiability is stage 1. Unless I can do it like this.
Thank you very much indeed.
Spinning between us, so I will go first on the case.
Yes.
So, if we can go to CB 42874, we can go to the word. I know you've seen it. Closure or restrictions placed on the premises on the advice with the approval of a medical officer of health for the public authority, resulting in notifiable disease occurring at the premises. Now, the way that the insurers would like this to read, they effectively redrafted this. Closure or restriction placed on the premises on the advice or with the approval of the authorised officer of the local authority as a result of the notifiable human disease occurring at the premises. And it's an obvious point to me. That's not what the clause says. They use the term medical officer of health. Now, one doesn't know how this term got in there. This may be a very old clause that was brought out of a cupboard that had not been looked at some time before 1970. It's common ground. They use the term medical officer of health, which is a redundant term. It doesn't exist as a term. The closest term to it is the Chief Medical Officer. And they do not use the term in this clause public authority, local authority. They use the term public authority, which is a term which, in my respectful submission, effectively means, in this context, the relevant public authority who actually imposes the closure or restrictions on the premises. And although the term medical officer of health is capitalised and public authority is capitalised, and you might think there might be a definition of those terms, there is no definition of those terms. Now, I'm not making a contra proferentum case at all. The point I'm making is on its proper construction, using the authorities which we know about, such as Rainy Sky and all those cases, their case doesn't fly, with all due respect. And certainly wouldn't fly if you apply the way the Supreme Court say you should construe policies, the way the reasonable policyholder would construe it. The reasonable, in this case, restaurant or cafe or sandwich shop owner, who are my three clients. And I hope, again, I'm not being a bit facetious, that really the authority that they are really relying on is the authority of Humpty Dumpty in Alice in Wonderland, which is, when I use the term public authority, it can only mean local authority. That's the case. It's not that it can mean local authority, it's that it can only mean local authority.
So your interpretation then rejects all of Mr. Howie's 6 candidates and says it is whoever is the relevant officer,
it can mean local
relevant
authority.
officer to advise about closure.
Exactly. It is who is the relevant officer who advises the relevant authority, and I will show you tomorrow probably, the findings of the judge, which are based on agreed facts, that there are powers that the local authority has and the central government has to deal with premises, and that is what it means. And also, they say that when they use the term medical officer of health, it can only mean, that's the case that's put to you, it can only mean an authorised officer of a local authority. And if the position is more nuanced, if the position is that public authority can mean either the relevant local authority or can include central government if central government closes the authority, and medical officer of health, which is a redundant term, but one has to do the best with the use of a term which has not been in use since 1974, means whichever is the relevant person with some kind of medical knowledge who advises the relevant authority. For the central government, it would be the chief medical officer, but one would have to find an equivalent officer who advises the local authority. That's what it means. And once you accept that they themselves have used in their policy, one, a term which doesn't exist anymore, hasn't existed for 50 years, and they use the term public authority, which is a term which can, as the judge rightly said, can refer to a local authority or central government. They've got nowhere to go. I mean, again, they are trying to be dictatorial to say this is the only meaning of these terms, and that attempt fails. And once you realise that the terms that they have used in their own policy are imprecise and would lead a reasonable reader to think that they are referring to the relevant officer who advises the relevant authority who closes the premises, their case is destroyed. And we are looking at policies which commence in late 2019, early 2020, which were sold to really, you've already been shown the premium paid. These are very businesses, high street restaurants or sandwich bars. And as I've said, by that time, the post of medical officer of health had not existed for nearly 50 years. And they then rely upon SB 36225, which is authority it's paragraph 17, SB 36225, agreed facts. If I can get it on my computer. Paragraph 7. See, by section 74 of the 1984 Act, an authorised officer in relation to a local authority means an officer of the authority authorised by them or either generally or specially to act in matters specified kind, by virtues upon purpose of matters when he is a proper officer of the authority appointed for the purposes corresponding to any of those of the former medical officers of health, surveyors and sanitary inspectors. But that officer is called an authorised officer. He's not called a medical officer. Section 74 does. It's which corresponds to those of the former, i.e. they don't exist anymore, medical officers of health, surveyors and sanitary inspectors. So that officer isn't called a medical officer of health, he's called an authorised officer. And the only office holders, but I'm not saying this is the only office holder that answers that description, but the only office holders as medical officers of health at the time were the chief medical officer, deputies, and the medical officers of the devolved authorities. And it is, with the greatest respect, rather contrary to insurers' has that this term, medical officer of health, cannot refer to the only office holders who were in existence at the time the policy was taken out, who answered that description: the chief medical officer and those who were his deputies, and the chief medical officers of the devolved authorities. And I don't know whether this is a convenient point, because I was going to talk about the powers of the government and the role of the chief medical officer in the judgment and based on the facts.
Yes, well, it probably is. Thank you very much.
Very great.
By my calculations, we start at 10 o'clock tomorrow, then you and Mr. Chapman, between you on the timetable, have until about 11:40. So you'll need to decide how you're going to split that between you. We've then got the insurers' replies, which won't take very long, and there is built in into the timetable that you've all agreed, what are called wrap-up reply submissions. So various councils better